All right, ladies and gentlemen, welcome to a Tuesday edition of the MSP Initiative Live. We bring back our special friend and legal guru, Brad Gross. But before I give him a chance to talk, I'm just going to go over some quick housekeeping because, I almost kind of faked him out there. That's okay. All good. So we did our MSP Community Block Party. You can actually check out all of the photos and videos from the event this past week in Orlando. Thank you to the great people over at Threat Locker and Danny and the crew. They did a great conference, and we were able to pull off a pretty cool block party. Here are the vendors that help us put that block party together, so we appreciate you. More of those coming later on this year, so stay tuned as we announce those. But the next thing that's imminently approaching is the Channel Strong Tour, and we're coming to Texas first. 1 week through Texas, but we did post all of our dates for the whole year online, right? So you can see on the channel at Channel Strong, you see weeks 1 through 8. They're 1 week at a time, where last year we were doing 2 at a time. If you're an MSP and you're in Texas, we'd love to see you come and join us. All outdoors, not that matters to anyone at this point. But if you're in Houston, San Antonio, Austin, Fort Worth, or Dallas, or all of them, and you're an MSP, we'll be out in parking lots of MSPs who are hosting us. We'd love to see you. So go to mspinitiative.com/channelstrong, and we will see you there. So that's all the housekeeping for today. Brad, how are you doing?
Hanging in there. Noticing that you were passing through Texas quite a bit. I was just down in Houston, had some of the best barbecue I've ever had in my life. And I own a smoker and I'm into barbecue. And after eating that, I actually sat back and thought, I don't know the first thing about barbecue, because once you eat that kind of stuff, man, it's changes the game. So,
well, for every Keith pops in, he's like, going to Texas specifically to honor America's only sports team. That's not true, Keith. They're just one of America's sports team. Let's just clarify for the record. Since we have an attorney on here, right? Facts matter. So that's number one. Number two, yes, we'll be in Texas. I know, Keith, that's not your part of the world usually, but I know you're always down for a good cigar. So maybe you'll join us. I know Darren likes to join us from time to time as we're bouncing around the country. He's on here too. Sometimes he brings Chick-fil-A with him. So, Brad, this past week we talked to a lot of MSPs, and it was great because in-person conversations where all the good stuff comes out, right?
Absolutely.
We can do webinars all day long, and they're good, but nothing changes that in the room, in-person conversation. And it just seems to me, Brad, I don't know whether all the security stuff, keeps on just boggling the mind of people, that we're missing just some of the actual like blocking and tackling. Let's use football as an analogy since Keith brought it up. Just blocking and tackling things. I feel like we get so convoluted going down the conversation on one or another.
Right.
We keep on missing, like, here's the basic blueprint that you should live within, right? And you can modify and adjust, right? Like,
you mean how you're offering security services to your customers? Is that the end?
Right? Just like, just because you're offering security services doesn't mean the rest of the stuff went away. Right? Like the computers still need to work, and the printers maybe still need to print, and the mobile phones still need to be able to get email, and the phones still need to ring, and the rest of the stuff didn't stop, right? So we get into this conversation about, well, how do I protect myself? And of course, all these people who are late to the Microsoft NCE, I know Ken Patterson's nowhere near me, game is just now figuring out that this risk has been put down, to the guy in between Microsoft and the end customer. And all of this other stuff is popping up as like technology changes, and the business, that's the point that I'm trying to get to. The business of technology changes too, right? And we are all hopefully in business to be profitable at some point and not, be working for free, but also to make sure that, one day we don't end up in a position that we're not looking to be in and maybe can't get out of. So that being said, I wanted to maybe go back over, and listen, we've been doing sessions with Brad for a long time, and his stuff, like the law hasn't changed that dramatically. Okay. Let's be fair. I mean, it changes, but not like wholesale changes overnight. Right. So Brad, I think a lot of it comes down to MSPs generally in business to help people, and they use technology to do that, but they can also hurt themselves in the process.
Agreed.
And, potentially. And like, let's just, let's go back to some of the basics, right? Like a lot of people don't get paid on time, Brad, right? They try and use cool vendors like a Connect Booster or something like that that automates payment, ACH, credit card, whatever. But sometimes people don't get paid on time. And guess what? The vendor on the other side of the MSP, they expect to get paid, especially when you have multiple customers attached to your partnership with that company. And maybe one big customer doesn't pay you, you're in a bit of a bind, right? So, number one, how do you protect yourself from not getting paid other than harassing people to pay you? There's a way to make sure that people understand that money has a cost, right? And not getting your money on time also has a cost.
Of course. Of course.
How do you protect yourself there?
Couple of things. So first of all, you may have just heard some noises in the background here. I apologize. Live video, my speaker went out for about 5 seconds. So that's what you heard, but we're back. I'm here. I heard you loud and clear after that. All right. So to back up and start at the beginning from where you're approaching. Yes, you're right. First of all, law doesn't change. All right. Law hasn't changed that often, I should say. It's not that it doesn't change. It doesn't change that often. And in fact, anybody who says, oh, laws are changing and the regulation is coming for MSPs and all, they're trying to panic you. I have not seen or heard of any significant regulation in the pipeline in any state in the United States. It's going to impact MSPs in the near future. Even laws that relate to security and privacy of MSPs, like those in Louisiana, for example, are largely fact and case specific. They relate almost entirely to MSPs that are dealing with governments and municipalities. And should there be a security breach, then there are certain procedures you have to follow, which are really just reasonable and normal procedures anyway. So I agree with you. Foundationally, you need to focus on the basics, as you just put it, the basics. You need to focus on the stuff that gets the bills paid, the stuff that lets you sleep at night, and you have to stop or at least squelch, to going back to CB days. I know I dated myself. You have to squelch out a lot of the noise, right? And so let's focus, and that's what you want to do. So let's do that, getting paid, right? I always find it fascinating when I'll speak to an MSP and they'll say, I have this customer, we haven't been paid in 8 months, in 9 months, whatever it is. And, that's not unique just to MSPs. That's any service business, right? Legal business, any service business. No business can continue with AR of 6, 7, 8 months. It just can't. And then, the amounts that we're talking about are sometimes staggering. It's not like, well, they haven't paid in 8 months, but they only owe me $5,000. Okay, I mean, that's real money. That's something, right? $5,000. No one's going to turn $5,000 away, but that's not usually what I hear. I'll hear they haven't been paid in 8 months. Oh, all right. Well, what's outstanding? $170,000. I mean, something so extraordinary that you almost question, like, why didn't you cut them off to begin with? And I think that when it comes to non-payment, there are a couple of things that MSPs would be wise to think about and have in their agreements to avoid this. Well, one is a business process and the other two are contract strategies. Business process. Unless you can afford to pay your bills with air or water, which actually water isn't even free anymore, you got to get paid. So people who aren't paying your companies, I mean, this is not just me speaking, having counseled thousands of MSPs. George is nodding too, because you understand this as a business person. If you're not getting paid, then all bets are off. I mean, why are we doing this, right? That said,
I think, and listen, I know where you're going, but I just want to throw this out there because it just fits right into the theme of things, right? Mm-hmm. Okay, so you haven't been paid. Can I safely shut people off? The gas company shuts me off. The electric company shuts me off. Can I shut this off? Because, hey, Brad, there was a guy right before the pandemic, I think it was 2019, where he was like dealing with the local chamber of commerce. He was providing services. He shut off their Office 365. Then like they filed, they had the local sheriff go and pick him up and arrest him. And I was like, whoa, what just happened here? This is a civil thing, right?
Yeah, in Georgia. Well, that was a weird case because that particular MSP, the client was the Chamber of Commerce, and it was a very, very small town, city, if you will, where everybody apparently knew everybody. And so the Chamber of Commerce made a call to the sheriff, and the sheriff went and, arrested this person. It was, in my opinion, totally improper arrest, totally improper procedure. The authorities should never have gotten involved with it, but you're dealing with small towns, and small towns sometimes things happen, right?
Did you ever? I don't know if you followed that case. Where did it end? Did it end?
I actually did reach out in that case to see if they needed my assistance. Never heard back from them, and as far as I know, it was probably settled, because it never really went farther than that. But I'll tell you that your point is a good one, in that you never know how far these things are going to go. You never know if somebody knows somebody whose brother is the sheriff. You never know, where this might end up. So instead of leaving it to chance, okay, what you need to do is you need to address these things right up front. So how do you do it? All right, first, you mentioned the electric company and the water company, and you are 100% right in drawing that analogy, because when you sign up for service with any utility, you accept the terms of their agreement, which I don't care if you read it or not, you accepted it. And what those terms say is, we can turn off your service if you don't pay us. Hard stop. That's what it says. We can turn it off. Now, we've all missed utility bill payment. Don't tell me you haven't. Everyone has at time to time. Then you get the bill, maybe you overlooked this, or prior amount still due. And okay, fine. Was your stuff turned off? No. Well, couldn't they turn it off? Yes. Well, why didn't they? Because they know that things are sometimes overlooked accidentally, right? And of course, they don't want the reputation of, you don't pay us on time, your water is done, your electric is out. So I think that MSPs need to protect themselves, but not be stupid about it. So what do you need to do? First thing, your MSP agreements must say that you have the right to suspend services if payment is not made. Now, should you do that? Probably not. What you should do is, I say, think of the rule of three. First, you send the bill. If they don't pay the bill, you send them a follow-up bill, not 6 months later, not 3 months later, maybe 2 weeks later. Follow-up bill. Maybe you overlooked our bill. That happens. We understand everyone's busy. So please go online and pay us, or do this, and so on. That's number two. If they ignore number two, then you send them number three. Number three is a more stern warning, right? You haven't paid the bill. If it was an oversight, or if payment's been made, we apologize, ignore this. But if it hasn't been made, please understand that. Lay it out. We cannot afford to continue to provide services when we are not paid, to pay our upstream provider. So your services will be suspended, and give a couple days. Give them a couple of days. Don't suspend it right away, but you really need to do that. You really need to do that. Okay. That's strategy one. Make sure that you can suspend services, but practice that with patience, right? Patience. Don't just cut them off after 1 or 2, but by the third, generally, I think the statistics show that if somebody hasn't paid within 90 days after, I think it's 3 or 4 attempts, the odds of you recovering plummets exponentially. It just plummets. So you don't want to get into that scenario. Now, what if you have to sue them? What if you have to arbitrate? Right?
Let me pause you for a second, because a lot of people have been, go down the collection agency route, and I know the collection agency will try and, take half or something, right? Everybody has different terms, but is that, you've been around for a long time, you've talked to a lot of people. Does that really work? I'm not sure it works. When do you go down
the collection agency route? Does it work?
Yeah.
The problem is that collection agencies have to follow the Fair Debt Collection Practice laws. And, does it work? Of course it works. I mean, there's a reason why they exist, right? They do work. Is it the most efficient and effective way? Probably not, because one, they will either buy the debt from you and try to recover it. And we don't know how that will work. They may end up paying you pennies on the dollar for it. Or if they say, we'll recover it for you and we'll just take a piece. Well, again, people don't like to or normally respond to debt collection agencies, or they simply respond back with, this debt is being disputed. That's it. Once you say the debt is being disputed under the applicable law, they can't just, put it on your credit report. Now they have to go through the process of, filing and pursuing a judgment and so on. So it's not that hard to get around a debt collector, or at least I take it back. It's not that hard to delay debt collection. But I'll tell you what does work. What does work is having an attorney's fees provision in your document. Now, why is this important? You'd say, well, do we need that? Like, they don't pay me. I get my attorney's fees. I'll sue them. I'll get my money and my attorney's fees. No, you won't. The way it works in virtually all states is that courts and arbitrators will follow what we call the American rule. The American rule says, it's a fancy way, it's lawyers call it the economic loss rule. Fancy way of saying, when you sue under a contract, you are entitled to recover that which you were entitled to receive under the contract, period. Are you entitled to receive attorney's fees? I don't know. What does your contract say? Well, it doesn't mention attorney's fees. Well, then you're not entitled to receive attorney's fees. Well, I spent 20 grand to get 15. Shouldn't I get it back? Yeah, you should. Will you? No, absolutely not. You're not getting it back. You should, though. I really, solidarity. I feel for you, but you're not getting it back. The way that you avoid this situation is you make sure that your agreement specifically and expressly says, if we are required to commence an action, collections or otherwise, to enforce the terms of this agreement, we are entitled, if we win, if we prevail, we are entitled to an award of our reasonable attorney's fees and costs. Now we revisit the economic loss rule. So if you sue under the contract, you're entitled to get what you would normally get. Well, what do you get? Well, it says right here, I get, what you owe me, plus I'm entitled to receive attorney's fees. Now you get that. And why is that important? Because it's one thing to say to a client or a customer who's not paying, look, you owe me $15,000, pay it, or we'll have to send you to collections. Send me to collections, who cares? It's another thing to say, look, you owe me $15,000. I'm going to call my attorney on Monday. He charges $4.50 an hour. So I haven't done that yet, but I'm going to. If you look in the agreement, it says, if I have to do this, you're going to pay that. So his clock or her clock will start ticking Monday morning at 9 a.m. Whatever it is, I'm sure it will outstrip the 15,000. So you could either pay 15 now, or you could pay 15 plus another 20 or 30 later on. Doesn't matter. I'm trying to save you money. That's a far bigger hammer, far bigger. If you don't have it in your agreement, you can't recover it.
Okay, so what we just went through is, going back to that really crazy example of the Chamber of Commerce and the guy who went to jail for some reason. So like, hey, you didn't pay. We gave you the rule of three. Still didn't pay. We came back to you and we said, hey, listen, we're gonna have to suspend. I can't keep on paying Microsoft in this case if they're expecting me to pay and you're not. So we're going to suspend. Okay. And then now your service goes down and then you still don't pay. And then we're talking about this whole, legal route, right? Which is, hey, like there's a cost. The challenge, let's just put a little bit of modern day in there, is that Microsoft's still going to charge you no matter what, right? Like their new rule is until whatever the end of that term is, right? Unless you pay the month-to-month premium, you're going to pay. So like, at what point does the clock stop? Do you, in that scenario, go after them for the whole term?
You're going for everything that you could have recovered and should have recovered under the term. That's it. Everything plus attorney's fees. Yeah. And I'll tell you, the case that you're bringing up in Georgia, if I remember correctly from a few years ago, that issue involved another corollary, to the whole you haven't paid me, which was that they wanted the MSP to transition them to another service provider. And the MSP said, I'm not doing anything, including giving your data back to you because you haven't paid your bill. And that became a whole thing. So not only was there a non-payment issue like you're talking about, there was a transition issue, right? But they're saying, well, wait, even if we haven't paid our bill, our data is our data. You still have to give that back to us. Otherwise, you're wrongfully holding it. And that's how they made a, quote, criminal case out of it. Again, I think it was ridiculous, but that's how they did it. So then it begs the question, well, how does all this fit into transition services? Let's say you haven't been paid, and now your client says, I want you to transition me away from you. Oh, and by the way, since you have a copy of my data, I want you to give me my data back as well. Now we have sort of a mixed bag. How do we handle that? I don't know. No, I'm joking. Come on. I'm with you. Of course, I know exactly how we handle that. Here's how we do it. What you're going to do, okay? What MSPs need to think about is that everything ends, and usually not well, okay? Usually. And I mean, it does happen sometimes that your customer will say, hey, listen, it's been great. I've been working with you. I'm just moving in a different direction. Your fees, right on point. Your service, perfect. But I'm not going to work with you anymore. I guess that happens. I mean, I've heard about that in legend, like sort of Loch Ness and UFOs. I've heard about it. I've never actually seen it, but I've heard about it. What usually happens is the client points to you and says, listen, I'm leaving because you're not performing. And of course, the vendor, the MSP says, I am performing. You don't understand what it means to perform. Okay. You don't get it. And so the whole concept is at that point, who's right? And in the meantime, you have a customer saying, give me my stuff. What do you do? And they haven't paid. All right. Every MSP needs to understand, since things aren't going to end well, you have to think about that in your document. Transition services in some capacity need to be addressed in your MSA because all services end at some point. I recommend that you make it very clear in your MSA that not only will things end, okay, as they do, but transition services are not free. I mean, I don't know where or who came up with the concept that since I'm leaving you, you have to help me move somewhere else. No, I don't. I don't. That's it. Why? Because that's a service, right? You hired me to perform A, B, and C. Well, now you're leaving me. Okay. A, B, and C is not transition. A, B, and C is A, B, and C. You want transition? That's not free, but you need to make that very clear in the MSA. And more specifically, you need to make sure that not only is transition not free, but you have to define what that means. And what that means is the recovery of passwords, right? The changing of configuration files, the downloading, uploading, provision of client data. All of that requires effort, right? It's not, I mean, if your technicians just sat on their hands all day, could that get done? No. Why? Well, because it's a service, right? So why aren't you billing for it? And the concept is that now we tie it into non-payment. Transition services should always be contingent on the client having paid all of its bills. If you want to be a little bit more even keeled, you could say that they are conditioned on the customer paying all bills that have been not disputed, right? Non-disputed bills, and all bills that are disputed must have been done in good faith. So they can't just simply raise something they never raised before. The idea is that you make non-payment a contingency, what lawyers like to call a condition precedent. Fancy lawyers' way of saying you got to do it first, right? Pay the bill, then we do transition. If you don't pay the bill, we don't do transition. And when you do that, when you put that in the MSA, what you've done is you've created, what do we call that? Oh yeah, a contract, right? It's a contract. You pay me, I do it.
Hold on. In that scenario,
yeah.
What about their data, Brad? All right, so they didn't pay you. They want their data back.
Their data is their data, right?
How do we handle that?
Their data is their data. No doubt, they own it. But where is it? Well, it's on your servers. What will it take to give it back to them? Well, it will take our technician to go in, download it, put it on a drive, spin it up somewhere, and virtually, I don't know what it'll take. Who pays that technician? Well, you do, right? You're an MSP. You're paying him for his time, right? So who's paying you to pay your technician? If you can't answer that question, you have a problem. You have to understand that just because it's their data, that doesn't necessarily mean that you have to work for free because you possess their data. The same way that if a car mechanic has your car and does the repairs and you walk in, you can't just say, give me my car, that's my car. Yes, it is your car, right? Pay my bill or you're not getting your car, right? I mean, there are a lot of different analogies that we can draw.
So here's the scenario. They haven't paid for 6, 7, 8 months, right?
Right.
Coming up to the end of that Microsoft term now, right? Coming up on 1 year. You're not going to renew with Microsoft. They haven't paid you, right? And if you don't renew, you know what Microsoft does? They delete the account.
Yeah.
Now what?
Now what?
How did that?
Good question. I'm not sure. So your stuff is deleted.
So Microsoft turns their account off and their data gets deleted as a result.
Right, because they didn't pay, even though they were told multiple times to pay, and the contract says you have to pay, and your contract should say if stuff is deleted because of non-payment, that's not on us. So they just ignore you and their stuff is deleted. Okay, now what? Okay. Now we go to Houston and have some barbecue. I don't know what you do. There's not a whole lot the customer can do. People are always
afraid about, data is one of those things, Brad, that it's hard to measure the value, right? Even the insurance, companies of America have struggled mightily trying to figure out, hey, the data, does the data of a doctor's office have a different value of the data of an architect's office? I don't know, but there's a value there, right?
No doubt. But the thing is that you cannot, and you're not required to take on the responsibility to protect the customer from itself in all scenarios, right? The same way that the electric company won't cut off your power, pretty much won't, right? We assume if you didn't pay 1 bill or 2 bills, maybe even 3 bills, they're not just going to cut off your power. Don't pay 4 bills, 5 bills, see what happens. They will cut off your power eventually. Now you could turn around and say, but wait a minute. I have an elderly parent who has a heart something plugged into the wall, right? A heart monitor or something. If that goes off, people could die. And the electric company's attitude is, yeah, they could. And that's it. You can't hot potato every issue that a customer has onto your company. You don't have the time, energy, or money to do that. So what you need to do is act responsibly, act reasonably, lay out the ground rules, manage expectations. And at that point, if the customer does something that is self-defeating or self-destructive, well, you look back and it becomes an interesting anecdote for webinars like this. Really, that's what it is.
Okay,
but you can't police everybody and save them from themselves.
Fair. So it sounds like the same condition would occur if, let's go back to the security conversation, right? All the security's in place and they don't pay their bill. And now the security services stop working because the services were suspended. And then the next day, the customer got ransomware.
Right.
And now they have a loss of business. Their business is down. There's an insurance company in the middle of that. The insurance company is going to say, well, who's responsible for this? And you're going to be like, well, it was these guys over here. And then now the cannon is pointed back on you, right?
Yeah, they're going to try. Obviously, they're going to point the finger at you. And that is something that when you're thinking about your MSAs and master service agreements, and you're thinking about your customer facing contracts, you need to, and I've preached this, I'm not just saying it now, I've preached it to you many times on these webinars. If a customer declines or does something to reject your service or does something that causes the termination of it, right? I'm telling you, they're going to point the finger at you. It's going to happen, which is what you just said. They're going to say, oh, I don't know, George was taking care of this. They're not going to mention, oh, I haven't paid George in 8 months. And I know he did tell me he was going to do this, but no, they're just going to say George did this. So you can't stop crazy people from doing and accusing you of crazy things. You can't stop that, but you can protect yourself such that it doesn't go any further than an inquiry by an insurance company or a bottom feeder lawyer. They said, why'd you cut off the services? What did you do? Well, let me show you. I have a contract that says we have the right to do it. I sent out 1 notice, 2 notices, 3 notices. All right. The contract actually says if we suspend pursuant to this, we are not responsible. Your client signed off on that. So where do you want to go from here? Oh, you want to sue? Okay. We have this attorney's fees provision going full circle now in the contract that says if this results in litigation or arbitration, whoever wins gets their attorney's fees. I'm thinking I'm going to win. Go for it. And that's where the conversation ends. So you don't have to protect clients from themselves, but you have to understand that they will request that you do so, for sure.
What about the concept of putting some sort of, and all the companies do this at some level, right? Late payment fee, percentage, if you pay your bill late past a certain point, some sort of, penalty,
Yeah, I mean, that's an interesting, it's always a viable option to throw in. It's sort of one of those throw-ins that you see in the payment section. Everyone says, we have the right to charge up to 1% or the greatest amount permissible under law, whichever is less, for unpaid invoices. All right, if you actually figure out how much that is, it never really amounts to much. And so, which is, I mean, think about it, which is more hard hitting, which is going to be more impactful. The cable company is saying, if you don't pay a bill, I'm going to charge you 1% per and up to 12% per annum on the outstanding amount that you owe. All right, yeah, that's interesting. So I might get a hit with a $5 fee, or they say, we're going to turn off your services at 6 p.m. tonight. You can't watch the season finale of Curb Your Enthusiasm or Euphoria or Game of Thrones. I don't know, pick your show, right? That's going to be more impactful when suddenly it's taken from you, something is physically taken, as opposed to just shelling out a few dollars on top. So I don't have a problem with charging interest and so on and so forth within the permissible boundaries, right, of the law, whatever the state you're in says. But in truth, that ain't going to get you where you want to go. That's not going to be your hammer. Your hammer is suspension of services. Your hammer is you're holding us harmless if we suspend services. And the ultimate is, oh, and by the way, if our attorney steps in, you're going to probably pay us more than you would ever think of paying us. So you might as well do the right thing. That's how you protect yourself.
Okay, let's go to another direction. So, we recently, I'm talking like last month recently, I think one of the big companies that had a breach turned out it was an inside guy, somebody working for the company, employee. What happens when you got a rogue person working for you that caused a problem? I mean, ultimately, the company that you're servicing is paying you, and they're going to say that person's your responsibility. You're on the hook, right?
Yep.
Create the worst
Almost
case
always
scenario.
you are. So it depends on whether the employee, look, there's a school of thought that says that when an employee goes rogue, and when an employee does something like that he is no longer, or she, I'll say he, don't mean it could be a she, obviously. He is acting outside the scope of his employment. It is an independent act, independent of what the employer permitted, or obviously. And so the employer cannot be held responsible for the acts of independent intervening acts, like criminal acts, of its employees. Okay, that's one school of thought. And it sounds good, right? And it certainly throws up a good defense, and you could charge money for saying all that and writing it in a letter. But reality is that if you have an employee that goes rogue, okay, and there was any hint of it, there was any sense that this could happen, he was angry, he was disputing something with the company, you didn't put into place sufficient processes and procedures to avoid something like this happening. Because again, bad things can happen from a rogue employee, but you know what? They can also happen from an employee that makes a mistake and the mistake isn't caught, right? So you get to the same point, right? Damage can be caused. One is intentional, one is unintentional, but probably should have been caught before it turned into something. So the reality is that virtually all the time, the employer, the MSP, is going to be held responsible for the acts of his employee under lots of theories. You weren't monitoring this guy. You weren't. You didn't have processes in place to avoid this type of thing from happening, even unintentionally. There were signs that this could have happened. You acted negligently in not isolating this person from the workplace, and so on. It's going to be very hard for an employer rather, to divest itself of responsibility when one of its people goes rogue. So the best thing that you can do and should do, I implore you, is to insure yourself, because you can do that. You can insure yourself against these types of incidents. I think you should have it. These days, everything is unpredictable. You get crazy people that do crazy things. There's absolutely no reason to not have insurance for something like this. There's no reason.
What is that insurance called?
It's called protect yourself from the bad people insurance. No, it's basically insurance coverage for the wrongful acts of your employees. Different insurance companies are going to call it different things under coverage. Is it covered under your errors and omissions policy? Is it covered under some sort of employee dishonesty rider or something like that? It really depends. You talk to your broker, they'll be able to tell you exactly what each different insurance company calls it, but it's something that you can and should insure against if you have a staff, a lot of technicians. You don't necessarily always have your eye on the ball at all times. Yeah, if it's 2 or 3 of you, it's one thing, but you might have 15, 20, 25 techs out there running around. It's something you need to insure against for sure. For sure.
I mean, it seems more likely now more than ever. It's a lot easier to get to the inside person to cause a problem, right? I mean,
100%.
I hate to think about that, but
and what companies really need to do is they need to put processes in place to avoid not only the rogue employee, but like I just said, to avoid situations where mistakes occur and they're not caught. You really need to have the buddy system, right? Everything needs to be checked and double checked because people make mistakes, and mistakes can cost you money. So you need insurance. You need to have the processes in place.
Okay. And this happens more often than anybody wants to admit, but somebody leaves the company, they go start their own shop, or they go work for somebody else. And then all of a sudden you start losing customers, and you're like, I wonder what's happening. And it turns out that person literally just went to the same customers and, convince them to move, right? Leave.
Yeah.
So
happens all the time.
How do you protect yourself against that? Because that happens too often.
So what you're talking about is the non-solicitation situation, not non-compete necessarily, but non-solicitation. So let's just make it clear. Non-compete is when you say to someone, you flip burgers for me, you cannot flip burgers for anyone else for a certain period of time within a certain geographic area. Okay. Mm-hmm. Both of which have to be reasonable, reasonably related and reasonable in time and scope. Okay, fine. That is not a non-solicit. A non-solicit doesn't say you can't flip burgers anywhere else. It says you could flip burgers. You could go right next door. You could actually open up, you could buy the unit above me and flip burgers from up there, but you're not going to take my customers and you're not going to take my employees. Other than that, you want to do what you want to do, knock yourself out. Most MSPs, in fact, I'm going to venture to say all, with very few exceptions, would and should have a non-solicitation provision in there. Non-compete, not so much. You don't necessarily have to worry about people competing. There's lots of business out there for everyone. Non-solicit means you're going to do things in a way that fair is fair. Not take my customers, not take my employees. Now, depending on the state you're in, you will be able to enforce that to varying extents. Okay. States like the one I'm in, talking to you right now from in Florida, you can. New York, you can. Texas, you can. I'm just thinking out loud, Washington. But go to California, it becomes questionable. Go to Colorado, it becomes questionable. The idea is that certain states restrict what we call restrictive covenants. And this is one of them, the non-solicit. So they have to be written very carefully with the understanding that in some states, you will not be able to bind, like California, you will not be able to bind your employee to a non-solicit, okay? You won't. What can you do? Well, you may be able to, notice I say may, you may be able to prevent not your employees from leaving and taking your customers, but you may be able to prevent your customers from soliciting your employees and stealing them away, right? Having them come in-house. Right now, we'll take California, for example. California has very, very long and strong policies against non-solicit. You can't enforce it against a person, an individual. But what if you're a business and you say to another business, not a individual, a business to business, we agree, I'm not going to take your employees, you're not going to take mine, okay, for a certain period of time. Is that enforceable? Well, it's an open issue. And I can tell you that I have argued successfully in California, not at the court level, but amongst lawyers, let's say, there is a strong contingency that says, yes, that is enforceable. Business to business is enforceable. Business to individual is not. Is that something you can bank on? No. You need to check with your locale and your local attorneys and so forth. But I would suggest that no matter where you are, you put those provisions in your agreement because they may be enforceable. In most states, they will be. And in any event, they will act to dissuade companies from stealing your people. And dissuasion is a big thing. You may remember, about 20 years ago, there was something called the club. Remember the club for steering
For the
wheels?
car,
Yeah,
right?
for the car.
Yeah.
You put it on the steering wheel. It was a big red thing. All right. When I was a prosecutor back in New York, and I was doing these minor theft cases and so on, and we would actually talk to the defendants in these cases, and they would say the club could break right through it. They had 100 ways to break through the club. All right. But what was the benefit of the club? And they would have told you this if you asked them. They said the benefit is there's so many cars that don't have it, right? You might as well just pick a car that doesn't have it. What do you want to spend the extra 25 to 30 seconds to try to break this thing? And then you might be seen and all. I'd rather just go to the next car that doesn't have it and I'm in, right? These types of provisions are like the club. They will work under most scenarios, but in the few times it's not going to work, it still dissuades. And if it doesn't work, so it doesn't work. Okay. The idea is you build your agreement in a way that it says, if this provision doesn't work, the court is allowed to just ignore it. Okay. Then put it in. What's the worst that happens? It doesn't work. At
All
least
right.
you tried.
So you bring up a good point. Like, let's say you're an employee in California, but the company is based in North Carolina.
Okay.
Which law prevails?
So the employees in California and the companies in North Carolina, in almost all circumstances, you're going to find that the California will extend its jurisdiction and protect its employees. It is and you have to pick the state that is the most pro-employee state in the country, maybe in the world, maybe, except for, I think, Germany protects its employees very well as well. But they will extend their jurisdiction for sure. I think that it is probably less likely to do so, the state, if the company is in California and the employee is in North Carolina, and you agree with the employee that the location of where they reside, that's going to control the transaction between you guys. California may take a step back and say, we're not here to protect a company from itself. We're here to protect the individual. Where's the individual? North Dakota. Okay. And that person agreed to North Dakota law. Yeah. Okay. This is not our fight. So if the individual is in a state that really is very restrictive, the odds are that that state will almost certainly extend its jurisdiction and you won't be able to enforce it. Almost certainly.
Okay. So outside of California and maybe a couple of states nearby,
yeah,
usually companies that only, like, not every company is incorporated in every state, right? I mean, usually they're incorporated in a state, right? And then
you register to do business in others. Yeah.
Correct. So, so outside of California, if you decide that the legal matters are dictated in a specific area,
Right.
that's where that's where things hold. No.
Yeah, well, generally speaking, that's going to be the rule. Generally, if the parties are always free to contract and they're free to select the forum that they want to use. And if the parties agree in advance that they're going to use a less restrictive forum and there is some reasonable nexus or connection to that forum, right, then you're going to, in almost all circumstances, you'll be able to use the less restrictive forums rules. For example, if the company's in California and the person is in New York, right, which have very, very different non-solicit rules, and the parties agree that we're going to use New York law to apply and to govern. Everyone agrees to that. New York law will probably apply. California will likely not get involved. However, if the company's in California and the employee is in Colorado, where it's tending to lean more in the way that California does, very restrictive pro-employee, and the company says, I have an idea. We're going to create a contract that says the governing law is New York. Even though we're in California and you're in Colorado, we're going to use New York law and New York venue, right? Most likely a New York court is going to turn around and say, no, you can't just forum shop and come here. And a California court or a Colorado court will probably turn around and say, we're not going to let you forum shop. Okay. I understand why you'd want jurisdiction in Colorado. I understand why you'd want in California, but New York, that's not happening. So you can't play fast and loose with it. There has to be some reasonable nexus to the forum, to the venue.
So is there some, here's a wrinkle.
There's always
What
a wrinkle.
what happens if, it's very popular to incorporate in Delaware?
Yeah.
So you're a Delaware corporation, but you're actually operating out of Texas. I don't know. You picked another state.
Yeah, sure.
Does the Delaware court still apply?
Yeah, you can at that point, you have a reasonable and rational reason, a nexus connection to Delaware, you'd be able to enforce Delaware law. Again, now, if you're in Delaware and the employee is in California, California will extend its jurisdiction, say, we protect our people. We protect people here. I understand you're a Delaware company. I understand you agree to Delaware law. We protect our people. So if you're dealing with individuals, be very aware of how the state that the individual is residing in, be very aware of how they handle these types of issues.
So so in this new world of remote working, where everybody's working from everywhere, where they actually live does make a difference.
It makes a huge difference.
Okay.
Sometimes makes the difference between whether you're going to enforce something or not. And remember these prevailing party attorney's fees thing. So you might go after somebody and lose, then you're paying the attorney's fees. So make sure you understand what the rules are, where the employee is, and understand your risks before jumping, for sure.
Does the same apply, with people working? Let's say you hire somebody in another country, could be Canada, be whatever, somewhere outside of the US, for example.
Right.
Are you now in a situation where their country's laws apply?
Wow, it's like I'm getting a flashback to constitutional law from first year. I'm going to bring my therapist into this webinar. Is that okay? Because I'm getting post-traumatic stress from thinking about law school. So if you're going to have a contract with a foreign country, foreign locale, Toronto, Montreal, Sweden, I don't care where it is, you're going to, again, you will almost always be subject to what they call long arm jurisdiction, a fancy way of, if you could think about it, like in your mind, conjure it up, the location literally reaching out, taking its long arm and saying, everybody's going to come and resolve it with our laws. That's what they mean. Long arm jurisdiction. You're pulling all these people in from all these different places, no matter how far they are, we can reach, take you and pull you in. And so depending on where you are and what country and so forth, countries will do that. Again, parties are always free to pick their forum and pick their venue, assuming there's a reasonable connection to it. But there are countries and there are states that will say, we feel so strongly about this, we will exert our long arm jurisdiction and force you to use our law. So it's not something that you could give a bright line rule and say, if you deal with Quebec, don't worry about it. The law can be, no, you really have to understand the nuances and act accordingly.
Okay. One last wrinkle on this one. Keith comes back. Welcome back, Keith. And he says, few of our employees have multiple homes. Right.
Yeah.
And
that must be nice. Yeah.
So that, their license says California, but in reality, they're spending all their time in Florida.
Right.
Does that change anything?
So they have multiple homes. The same way that a company is not going to be permitted to forum shop, okay, and just simply say, well, I have an office in New York and in California and in Texas and in North Dakota, so I'm going to use North Dakota law. No. There has to be a relationship, a nexus, a connection. What's good for the goose is good for the gander. You can't have an employee who says, well, I know that I've told you that my main residence is in New York. That's where I pay my taxes, let's say, right? You got to pay it in some state. So I pay my taxes to New York. But you know what? I spend 4 months out of the year in California. And California is where I was when you fired me. And so, and I plan to be here for at least another few weeks. So as long as I'm here, you can't enforce that non-solicit against me. Oh, no, 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 no. No, it doesn't work that way. Employees can't be a moving target and move and form shop to where they want to go. They pick a place, and that's where they're going to be held. Usually it's the place of their residence, the place to which you are sending a paycheck, to which their W-2, lists, or their, 1099, whatever it is. Whatever address is there, that's generally where they're going to be stuck, for better or worse.
There you go, Keith. There's the answer to your
There you
question.
go.
So let's use the last few minutes here just to talk about some of this is just kind of back office things, right? Hey, you created an MSA 4 years ago. Things change. You wanted to adjust your MSA. Like now there's multiple versions of your MSA out there based on when people sign things. Like there is some sort of logic to making sure that things are in an orderly fashion, right? So you don't get stuck on this version versus that version, or hey, you started adding more services and you needed to go back and adjust for those, right? What's the best way to do that?
The best way to what? Go back and adjust your MSA and to
Yeah.
So look, I've always said that if your MSA is written correctly, you probably don't need to address it more than once every 3 years or so. Yeah, about once every 3 years, it should be reviewed, looked at, and so on. Okay. That said, let's say that you have an MSA that you've been using and you realize it does need to be addressed. It needs to be adjusted. What to do? Well, you cannot unilaterally force a new MSA on a client. Impermissible. Contract law says it has to be a meeting of the minds. We have to agree. I can't just turn around and say, I've decided that as of tomorrow, my liability is lowered to 3 months instead of 12 months. What? No. So what do? Well, either you implement a new MSA, new customer facing agreement, with the understanding that that is your document moving forward. So anything that you move forward with is covered under your new MSA. And the idea is that the old services will drop off by attrition, right? Maybe, they have another 8 months left in the contract, whatever, but when they renew, the renewal is done under your new MSA, right? So they drop off by attrition. Another way is to ask the customer to accept your new document. Ask them. Parties are always free to contract amongst themselves and agree or disagree to things. We're free to do that. So if a customer says, yeah, I agree to your new MSA, this can control what we're doing from now on. Okay, you're good to go. Now, how do you do that? That requires some finesse, right? You're going to have to talk to your customer, maybe blame it on the attorney. I like to tell clients to do that. My attorney says that that you're not operating under the latest version of our documents, and he requires or she requires uniformity. So here's what we're doing. We're doing this, 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 this. We ask that you sign off. This will be our understanding moving forward from today's date forward. If you have any questions or concerns, please let us know. Otherwise, by signing it, you understand that this is how we're going to do things. A lot of clients will sign off on it. If you're not changing the term or the pricing or the scope or the fees or anything, a lot of clients will just sign off on that. And if they do, good for you. Otherwise, do it at a renewal point and let those old services die off by attrition.
Okay.
Sure.
There you heard it, folks. I mean, a lot of this stuff, like there's like a foundation to everything, right? And then as technology and the business of technology and the money of technology changes, like you have to be able to build on top of something, right?
Right.
And so this is the blocking and tackling that Keith started us off earlier in the call, where it's like, hey, like, don't forget about this stuff, right? It's almost like, hey, you keep on adding all these security services, like the computer still needs to run, right? Same thing here, right? This stuff needs to be really thought through and planned out. And that way you have something to build upon, because otherwise, you're on a little bit of quicksand, I think. And then, let's face it, the opinion of every, arbitrator, judge, whatever, I mean, could drastically be different, from one room to another.
You're right. So,
good to have your paperwork in order, guys. So I brought Brad on today. Like there's plenty of stuff to always talk about, and current events always keep things interesting, but these are things that you really just need to have sorted out. And quite frankly, for the guys out there that have a, constantly have to go back out and, renew your insurance and renew your, all of the stuff that comes along with, with insurance companies and how they, determine your premium and all that stuff. Right. I mean, this is they ask for a copy of your agreement, right? I mean, this is part of their process.
Absolutely. And by the way, dropped out there for a moment. Again, live webinar, it happens. It's okay. Yeah. I'm back. So if your point is that insurance companies want to see this stuff, right? Increasingly, not only do they want to see this stuff, they actually want to know the vendors you're using. How about that? They are getting, because they realize that the liability is increasing, that the potential for payouts is increasing. So not only do they want to, it used to be do you have an agreement? Yeah. Does it limit your liability? Sure, it does. Now they want to see copies of this agreement. They ask very specific questions about indemnity, about limitations of liability, about third-party versus first-party services, about issues related to failure of upstream providers and so forth. A lot of this stuff is now being asked in the due diligence phase of insurance companies, and it is not unusual, maybe not often, but not unusual for a insurance company to say, please tell us which providers you're using for the following services. Boom, 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 boom. Because they want to know, right? They want to see that you're using a top shelf, understood, a top shelf recognized provider. They don't want to see, Joe's Computer Services out of, Miami. Oh, they handle our security services. You're going to be paying a little bit more. So the idea is that you definitely want to have all of these things in place, from agreements to vendors, have it all in place. It's really becoming the norm.
Okay. Well, we will continue to bring Brad back throughout the year. Always interesting things happening. Hopefully we'll get him out on the road one of these times. I'm sure when we're in Florida, we'll definitely see him.
Oh, for sure.
Otherwise, you can come back and see him here while we throw interesting, scenarios at him, and he comes and tries to bring us back down to earth. Can't stress enough, make sure your paperwork's in order. Have somebody take a look at it. If you haven't had that done in a while, Brad's a good resource for you. And you can find Brad
well, first of all, phone number, right? 954-217-6225, info@bradleygross.com, or check out the podcast, right? technologybradcast.com. So it's technology Brad, not podcast, technologybradcast.com. Yeah, a lot of good information there, and you can reach me through that as well.
Awesome. Well, Brad, we'll have you back in the near future. Thanks for answering all of our crazy questions.
Thanks, George.
And we'll see you on the other side.
Take care.
You got it, guys. Have a good one.